Welcome to ImmigrationQuestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, ImmigrationQuestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by ImmigrationQuestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is GB Satusa, and I'll be your host for today's discussion, Family-Based Immigration. How long does it take to get a green card through family sponsorship? One of the most common and hopeful paths to U.S. permanent residency is through a family-based sponsor. But the timeline can be confusing. Visa categories, quotas, and processing backlogs all affect how long it takes for a family petition to turn into a green card. Understanding realistic timelines, bottlenecks, and strategies to avoid delays is essential for both petitioners and beneficiaries. To help us break this down, we are joined by attorney William Gerstein Esquire, a board-certified immigration attorney with over 28 years of experience guiding families and individuals through U.S. immigration. Attorney Gerstein has successfully handled thousands of family and employment-based cases, removal matters, and waivers. Fluent in Spanish and Italian, he brings a disciplined, client-first approach, making him a trusted advocate for immigrants seeking stability and a place to call home. You're welcome, Attorney Gerstein. Thank you so much for joining us today.
My pleasure to be here.
Now, before we begin, a quick reminder, ImmigrationQuestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals and families can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and pens and share the link with your friends. If you have not subscribed, now is the right time to do so. Just click the subscribe button and you're all set. Now, let's dive right into today's session. Attorney Gerstein, can you break down the realistic processing timelines for immediate relatives compared to family preference categories in 2025? Which categories are currently facing the longest delays and why?
Okay. So immediate relatives means that there's no limit on the number of visas that are available. So just depending on how and where and when you're applying will dictate how long it will take. So for example, if you were applying for adjustment of status in the US, it literally could take as little as maybe 4 months from submission until interview and approval. If you're applying from outside the US, I would say it's going to be more in the line of about 18 months. And how does it compare to the preference categories? Well, the preference categories 1 through 4 are based on different types of relationships. And there's visas available in each of the categories, which are pretty much all backlogged. So in our first preference, we have the unmarried adult children of U.S. citizens. In the second preference, we have an A and a B. So the A is the unmarried children of minor children of a permanent resident and spouse of a permanent resident. That's as close to an immediate relative as far as the timing as you can get. In the B, you have the adult unmarried children of a permanent resident. Then in the third preference, you have married adult children of U.S. citizens. And in the fourth preference, you have siblings of U.S. citizens. And certain countries have their own separate backlogs. For example, India, Mexico, and the Philippines. So if you wanted to sponsor a sibling from Mexico, for example, it could be backlogged by about 30 years.
Right. So you've touched base on this briefly, but country-specific backlogs remain a significant challenge for applicants from places like Mexico, the Philippines, India, and China. How do these backlogs form? And what should families from high-demand countries expect when planning their timeline?
Well, the way that they form is because no one country can occupy more than 7% of the people that in the world that they're sending to the United States. So, for example, we can't have more than 7% of the people being Indian or Chinese or Filipino or what it may be. So, for example, in the first preference category, which is the unmarried adult child of a U.S. citizen, for most of the world, it's backed up by approximately 9 years. But if I look at the backlog for Mexico, it's backed up by 19 years. If the person is in the United States, they have to have a valid non-immigrant status, such as a student or an employee like an H-1B or maybe an E-2 investor. But you cannot have any time out of status or immigration violations in these categories because there is no forgiveness for them. So if you cannot maintain status while you're waiting, then your plan really needs to be to wait outside the US.
Right. Many families underestimate how much USCIS and National Visa Center workflow changes affect processing times. What internal factors or policy shifts have contributed most to delays this year? And is there anything applicants can do to adapt?
Well, I would say that the delays are caused by extreme vetting from the current administration. So whereas maybe in the past, some deference may have been given to people's applications, now we're seeing almost every category being interviewed where interviews would have been waived in the past. Really, the best way to be prepared is to give them everything accurately up front the first time, which is most of the reason that people hire attorneys, because they know that we're trained and equipped and have the experience on what to do and how to do it and when to do it. So that is really some of the best things that you can do.
Now, from your experience, what are the most common mistakes made in I-130 filings or supporting documentation that significantly slow down processing? And what practical steps can families take to prevent avoidable RFEs or denials?
Well, for example, they may pick the wrong category, which would probably route the case differently. They may not provide certain evidence that's needed. So I'll give you an example. If you have a father sponsoring a child and the child was born out of wedlock and never married, the father never married the mother, then you have to provide evidence that the father had a relationship with the child before the child was 18 years of age. Most people don't realize this and would probably just send in a birth certificate without addressing this issue. And then it would lead to a request for evidence and a scramble on their part to obtain the evidence before the stay expires. Not sending in translations, not sending in evidence of relationship, particularly in marital cases. Those are pitfalls to be avoided. And as a law firm, or a very experienced law firm of 30 years, we have detailed checklists that we make sure that before anything leaves here, that all of these things were addressed. And each person that touches it along the way has responsibility for ensuring that their part of it has been accurately completed.
Right. For beneficiaries already in the United States, maintaining lawful status during long waiting periods is a genuine concern. What strategies or options do applicants have to remain in good standing while their family-based green card case moves forward?
They really have to find a non-immigrant status that suits them and suits the period of time that they need to wait. So, for example, if somebody expected that they were only going to have to wait a year and a half or 2 years, maybe they would start off as a student because they could theoretically be in that status for 4 or 5 years. Or they may come as an investor, which could be for up to 5 years at a time. So these are different strategies that we would employ to try to keep people in status throughout the whole time. Sometimes it's really just not practical or possible, so we have to condition them or manage their expectations. To say that, well, you might be able to visit the US from time to time and visit your relative here. You really need to plan on maintaining your life abroad until such time comes as you receive your interview and your immigrant visa.
Now, when a case stalls at USCIS or the National Visa Center, families often feel powerless. What proactive measures, such as inquiries, congressional assistance, or case tracking, are actually effective in keeping an application moving?
First of all, people need to realize that even though processing may be taking a long time, if it's not passing their priority date, it doesn't really matter how long it takes. It's not bringing them any closer. So let's say that I file a case on January 1 of 2025, and the category is backlogged by 9 years, and I get a receipt, but 4 or 5 years have passed, and I haven't gotten my approval or I haven't gotten other correspondence. It doesn't honestly matter because unless you were close to that 9 years of backlog, it doesn't bring you any closer. Now, if it does pass the stated processing time, there are tools online with the USCIS that allow you to inquire and to make a complaint. If you are aware that something might be missing and you have electronic access to your case, you can upload things. You can even upload inquiries, and when I say things, I mean evidence. And we do find congressional or senatorial inquiries to be helpful. Some of the congressmen have a setup where they have a form where you fill out and they allow you to attach and upload documentation so that they have the full story. Others just say something like call us or stop into our local office, which I think is less effective. So, for example, we had a client whose congressman that their instructions just said, stop by or call us. So we said, this isn't going to be practical or effective because the constituent isn't really going to be able to articulate how they need to be helped. So instead, we looked at the websites of the state's 2 senators, and actually both of them did have those formalities of the forms to complete and the ability to upload attachments. So we chose that method as more effective.
Right. To everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for tuning in. Whether you are sponsoring a family member or being sponsored for a green card, today's session is designed to give you clarity, structure, and confidence. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where immigrants, families, and professionals can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We're also proud to share that ImmigrationQuestion.com is a BBB accredited business, reaffirming our commitment to transparency, accountability, and service to immigrant communities across the United States. Attorney Gerstein, with your extensive experience in family-based immigration, what are your thoughts on how a platform like ImmigrationQuestion.com helps families connect with attorneys and navigate complex processes more effectively?
Well, you're sort of crowdsourcing information. So, instead of maybe just going to your one friend who went through the process, you would be part of a community where you could see what's going on in real time. What are other people experiencing? How are other people dealing with it or managing? So a platform like this gives you those opportunities that otherwise don't exist.
Thanks for that perspective, Attorney Gerstein. Before we move into our live Q&A, I think our audience will want to know this. What practical strategies would you recommend for families to track their cases, maintain status, and avoid delays while waiting for a green card?
Well, first of all, they should set up an online account with the USCIS where notifications come whenever there's news, so that they can log in with some frequency, or if we know that it's going to be a long wait, maybe they would log in at least once a month, or they can access apps such as the one that you're offering that would track the case and provide them with up-to-date information. If a request for evidence is issued, they give you a specific deadline, and they also tell you the preferred method of how to send it in. Usually they will want you to upload the response online in their online portal, unless it's something original that they need, like a medical exam or a passport photo, or perhaps an original birth certificate or something of that nature.
All right. If you've just joined us, we've been in an insightful discussion with Attorney William Gerstein on family-based immigration. How long does it take to get a green card through family sponsorship? We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible during this session. My spouse filed I-130 1 year ago. How long must I wait before interview or green card?
What I tell first of all, we would have to know if this spouse was a U.S. citizen or permanent resident, because that obviously affects how long it would take. But assuming that the spouse was a U.S. citizen, I tell clients that our experience, because we filed many of these cases, that generally the interview is between 6 and 12 months. If you don't receive an interview within what you consider to be a practical time frame, what you would do is go to the USCIS website, where you could look up processing times, and then you would look up what it is for this petition or adjustment of status at the local office, if we're talking about somebody adjusting in the US. And if it's past that time, you file an inquiry or a complaint, or possibly a congressional inquiry. If it hasn't passed, then unfortunately you have to be patient and wait.
All right. If I sponsor my sister for green card, can it take up to 10 years?
So it practically would take at least 20 years. So if we look at the current bulletin, the visa bulletin, which comes out every month, they're up to January of 2008. So that means that it's approximately 18 years backlogged. And the issue is that these dates don't necessarily progress a month at a time. So if I look at, or if I anticipate what the January of 2026 visa bulletin would say, it's not necessarily going to say February of 2008. It might not move at all. It might move slightly. It might move backwards, or it could move more than a month. But it's something that you have to monitor, I would say in a sibling pick case, at least a couple of times a year. But to manage expectations, I would say consider at least 20 years.
All right.
And again, only a U.S. citizen can sponsor a sibling.
Okay. How do visa bulletin date for filing and final action dates change? And when can I get my green card?
So every month, the USCIS publishes on their website, whether we're talking about employment-based or family-based, they will say, for the current month's visa bulletin, you are to use whichever. Let's say it's the final action date. And then it'll say for next month's visa bulletin, you should be using, for example, the dates for filing. Now, the good thing about the dates for filing, especially if we look at a family-based preference case. So if we look at the F2A, right now it's the F2A again is permanent resident sponsoring a spouse or a unmarried minor child. So the final action dates are February of 2024. However, the dates for filing are up to November 22nd of 2025, which is current time. So that is something where it really would give a family a jump start. So they would be able to file much, much sooner and be in process to get a work permit, be in process to get an advanced parole travel permit if applicable, and at least to rest easy that the application is now pending.
All right. My visa category is F2A, and I heard it is sometimes current and sometimes not. How will I know?
Okay, so you will know by looking at the monthly visa bulletin. Now, what you have to understand about the dates for filing is that that's just a privilege to be able to file sooner. They cannot approve your case until the actual final action dates have been reached. But to answer the question, you look at the visa bulletin, you look at the final action dates, and it either says C for current or it has to, your priority date has to have already been included in it.
Okay. If USCIS approved my I-130 but later changed rules, can they still put me in removal?
It's kind of a loaded question, so we don't know what rules the writer is asking about changing. Can they still put me in removal? So you have to understand the I-130 is a petition that when the priority date is current, when it's approved, then you can apply for adjustment of status. So let's just take an example that you have somebody here who's out of status, a relative files an I-130 petition for them in a category that's not current, in a category where we can't file the adjustment of status. So just the fact that they filed the I-130 or even the fact that it's been approved doesn't mean that the person's not removable. An approved I-130 itself does not confer any status.
All right. How long is NVC currently taking to process packet and send interview date?
Here, I would say it depends on how busy the embassy or consulate is. Sometimes it might be as little as 3, 4, 5 months. Other times I've seen it could take well over a year. The cases that we have, for example, in Lagos, Nigeria, definitely take more than a year because there's probably a high demand and maybe not as great of a capacity to interview or vet all of the people that are applying. So it very much depends on that.
All right. Attorney Gerstein, as we wrap up, let's digress a little to one of the hot button topics in the immigration space right now. With the new H-1B rules changing hiring practices, what impact do you see on employers' recruitment strategies, and how are OPT students affected by these changes?
From what we can tell, people should still be able to apply for a change of status to H-1B from student. So in that sense, I think that things would probably remain the way that they are. What's somewhat unclear is where the $100,000 surcharge fits in. Does it mean that if they leave the US and they apply for a visa to come back after visiting their family, is it payable at that time? This is what remains to be seen. In our practice, we haven't seen anybody yet that has paid the $100,000. And of course, that weekend in September that the news came out, it was very haphazard, where a lot was not explained, but tried to be clarified later. And I think we won't really know for sure until more people are affected by it and the visa lottery starts in March. If any employer is going to be subject to the $100,000 surcharge, I think it's going to eliminate 99% or more of these cases, and that it would only maybe apply to the absolute most valuable employees that would be generating great income for an employer. Otherwise, it's a burden that's too far for most employers to handle.
Well, thank you so much, Attorney Gerstein, for your time, expertise, and clarity today. Your discussion has given families the guidance and confidence they need to navigate family-based immigration, anticipate delays, and plan effectively. And to all our viewers, thank you for joining this meaningful conversation. We hope today's webinar helps you stay informed, organized, and prepared as you work toward securing a green card through family sponsorship. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and network directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's webinar or share it with others, the full replay will be available on Spotify very soon. Search for Borderless Talk by immigrationquestion.com. Join us again next week for another live session exploring key immigration topics, including asylum updates, family petitions, employment visas, and compliance strategies. Once again, thank you, Attorney William Gerstein, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected.